Be ready for the dictation. The dictation speed is 120 words per minute. 5 seconds to go. A bench of justices, while hearing a petition against the Chhattisgarh High Court order to take bail plea in due course while refusing interim protection to an accused, said that it was an unusual practice adopted by the High Court and disapproved it. Ordinarily, this court, where there is refusal to grant interim relief, is not inclined to interfere, but this is a somewhat peculiar fact brought to the notice of this court, where the applicant who approached for seeking anticipatory bail, the London judge of the High Court, while admitting the bail petition, dismissed the interim relief and posted the matter for hearing in due course. This is an unusual practice which this court has never come across, the bench said. We also disapprove such practice and request the Chief Justice of the High Court to take a judicial note and at least the bail applications, whether it is pre-arrest bail or post-arrest bail, must be decided as expeditiously as possible. Although we are not supposed to give any guidelines for the disposal of the bail applications, but at the same time, we always expect that bail applications must be decided as expeditiously as possible and not to be posted in due course of time, the bench said. It also noted that another apex court bench had earlier raised this issue and had said that such a procedure for hearing of bail plea cannot be countenanced. We are of the considered view that this type of indefinite adjournment in a matter relating to anticipatory bail, that too after admitting it, is detrimental to the valuable right of a person. We find it necessary to emphasize that when a person is before the court, and that too in a matter involving personal liberty, least what is expected is for such a person to be given the result one way or the other based on the merit of his case, and not push him to a position of uncertainty or be condemned without being heard, the court had said. Wide impugned order 1 passed by the High Court, an application filed by respondents number 1 for amendment of the plaint was allowed. The facts available on record are that respondents number 1 and 2 filed a suit for partition of the ancestral property belonging to their grandfather, pleading that no actual partition of the property has order dated 18/8/2010 passed in writ petition number 82086 of 2010 to High Court of Karnataka Circuit Bench. When the suit was at the fag and an application was filed by respondents number 1 and 2 seeking amendment of the plaint. The amendment sought was to add prayer in the suit for a declaration that an earlier compromise decree dated 14/10/2004 was null and void. As prayer was not made earlier, the court fee required thereon was also sought to be affixed. The ground on which the amendment was sought was that due to oversight and mistake, the respondents number 1 and 2 were unable to seek the relief of declaration. No prejudice as such would be caused to the defendants, as limited relief is for fair partition of the ancestral property.